SJC-12359, Carleen Vilbon v. Board of Registration in Nursing.
Good morning, Mr. Vilbon. You've got 10 minutes. You should walk over and speak at the microphone, and you may proceed.
Okay. Hello, everyone. My name is Carleen Vilbon. I would like to present my oral argument. The issues are the lower court improperly allowed the respondent to have concurrent jurisdiction, which led the board to in violating General Law, Chapter 30A, Section 14 and 6, and incorrectly ruled its judgment on the petition of the respondent filed pursuant on General Law, Chapter 112, Section 64, which interfered with Justice Spina's order to the board to file its answer brief within 30 days after my former attorney submitted my brief. My argument: the lower court did not only fail to enforce its order, but allowed Assistant Attorney General Benedon to file the board's revised order and final decision without leave of the court. If that court denied appellant's motion to introduce extrinsic evidence, it should have also denied the board's petition. See docket entry number 23 to 25 in that situation. The board acted as both party and judge by concurrently ruling a decision by stating on page 1 of its answer brief, the court lacked jurisdiction to review my complaint. Noted that the board's attorney, Amy Fine, tempted me to sign a non-disciplinary consent agreement for permanent cancellation containing a false expiration date of my nursing license, which contradicted its true expiration date. See appendix 10 to 14 and 32. She also recognized that the board committed an error in revoking my license, appendix 13 and 14. Although Mrs. Benedon and my former attorney had tried to settle the case, the board did not remove the fraud and deceit accusations from the National Data Bank and failed to compensate me from loss of wages for approximately 2 years as per GL Chapter 30A, Section 14, 7, and G, as prescribed. The board should not rely on unsuccessful settlements and failure to file its answer brief to support its petition, but should be consistent to the relief I requested in my complaint, which was the main reason I stated on October 3rd, 2012, I must appeal its decision of September 12, 2012. See Appendix 72, Paragraph 1. Justice Laurie should have based his ruling on the appellant's brief, which Attorney Shiofi submitted on my behalf. But he unintentionally accepted the revised order and final decision of the respondent, ignored to enforce Justice Spina's order, and ruled the matter as moot in favor of the board. Noted, Attorney Benedon tried to manipulate the appeal's normal process in stating on page 12 of the respondent's brief the basis for Ms. Vilbon's General Law, Chapter 112, Section 64, petition no longer existed after the board issued its revised final decision and order, because she did not file a motion to introduce such extrinsic document on record. Such violation led her in vaguely disguising the concurrent jurisdiction by mentioning on page 8 of the answer brief, the court requested the counsel for the board to provide an update on the status of Ms. Vilbon's license. If that court made such request, it would have notified my attorney and would have docketed such notification. The first document the lower court docketed in 2017 was the respondent's petition and final order filed on April 3rd, 2017, which I opposed and which Justice Laurie took under advisement. Paper entry 33 to 35. Therefore, I respectfully request this court to review the record on appeal and to disregard the board's petition in order to reverse the judgment and remand this case for further proceedings, which is in the best interest of the public. Justices, I have made copies of my argument. If you would like, I can present what I have read to you. It's in writing.
You can furnish that to the clerk, and we shall make it part of the appellate record.
Also, I would like to emphasize that per the National Data Bank, the correct way to remove the false accusations on my record is by a court order to void the record, and it was not done by the Board of Registration in Nursing. And I have this procedure of the National Data Bank to provide to you as well.
All right, thank you. Thank you. You may sit down, and I will hear from Ms. Benedon. Still good morning?
Good morning, Your Honors. A few more minutes left of morning. May it please the Court, Assistant Attorney General Carrie Benedon on behalf of the Board of Registration in Nursing. This Court should affirm the single justice's dismissal of Ms. Vilbon's petition for judicial review as moot. Although the Board of Registration in Nursing had initially found that Ms. Vilbon had secured her Massachusetts nursing license through deception and dishonesty, after Ms. Vilbon filed her petition for judicial review, the board reconsidered that decision, which case law of this court establishes it clearly had the authority and the jurisdiction to do. And the court then issued a revised final decision and order that expressly removed the dishonesty and deception finding. The court then submitted an update accordingly to the National Nursing Bank that Ms. Vilbon mentioned.
Yeah, if you would stop there for a moment. If Ms. Vilbon were to seek to find a job in Pennsylvania, and they were to go to that data bank to do their due diligence with respect to her, what would they find with regard to this matter?
This would show that the data bank shows that Ms. Vilbon, that the board had suspended Ms. Vilbon's license for two reasons initially. One was that she lacked the educational requirements for licensure in Massachusetts, and she has never disputed that point, not before the board, not on judicial review, not in her brief to this court. And then also that her license was suspended because of this dishonesty determination. Then the board submitted an update to the board, and so now there is an entry stating that the finding of deception and dishonesty was submitted in error and was withdrawn. The reason that the board did not completely seek to have the suspension removed from the registry is that the suspension on the basis of the lack of the educational prerequisites was undisputed, and to this day is undisputed. So the fact that there was a suspension for a period of time on the basis of the lack of educational prerequisites stood and was never challenged, and so that's why it does still show that there was a suspension for a period of time, but there is an entry, again, expressly stating that the dishonesty and deception determination was entered in error.
And is there an entry that would reflect that she has corrected her educational, not corrected, but has made her educational requirements and is now qualified to practice nursing in Massachusetts?
I don't recall exactly what it states in that regard, but Ms. Vilbon's license was reinstated without restrictions. And so if somebody were to check the status of her license in Massachusetts, it would show that it now is expired, to my knowledge, but that it was reinstated without restrictions and then she allowed it to lapse. I do want to address Ms. Vilbon's assertion that the board lacked the authority to reconsider the matter while the action for judicial review was pending. I point the court to two cases that I did not cite in my brief. They are Moe versus Sorb, 444 Mass 1009, and Olmsted versus Department of Telecommunications, 466 Mass 582. Both cases presented essentially the same argument, where an agency reconsidered its decision in a way that was favorable to the appealing party. The appealing party challenged that the boards lacked the jurisdiction to do that and that it did not moot the cases. And in both cases, this court expressly found that administrative agencies retain their inherent authority to reconsider and to correct their own decisions when appropriate. And again, both of those cases involved reconsiderations while an action for judicial review was pending. And to only briefly address the assertion that the submission of the revised final decision and order was inappropriate, that was done in response to a request from the single justice after Ms. Vilbon's attorney filed a letter with the court stating that the matter had been settled and resolved and the case should be closed. Ms. Vilbon then filed her own letter disagreeing, and so the single justice presumably asked the clerk to call me and said, "What's going on? Can you submit this revised final decision and order that they have referenced?" And so I submitted it. I did not believe it would be prudent at that point to file a motion for leave to do so when the court was the one that had asked me to submit it. And I will also point out that the board did not file a motion to dismiss as moot. That action was taken sua sponte, so this was not a motion to dismiss with a ton of extraneous documentation inserted as well.
Just going back to the data bank,
Yes.
is there an option to strike or actually remove any reference to deception or dishonesty with regard to Ms. Vilbon?
No. I have been told that it is not possible to do that because it's not possible to change a prior entry. It is only possible to submit an additional entry that would clarify the prior entry. That is my understanding, and that is what the board did, where it submitted an entry stating that not simply that the board reconsidered, but that the initial finding and submission had been in error. The other arguments that Ms. Vilbon raises are simply not matters that are proper subjects of an action for judicial review, such as her assertion that her attorney should have been able to secure a monetary settlement or that she should have been awarded fees. None of those issues would have been properly before the single justice. For these reasons, Your Honor, the single justice properly dismissed this action as moot. Thank you.
All right, thank you.
Court all rise.